All right. Hi, everyone. Are we ready? We're ready. All right. Welcome, everyone. Hope you had a good morning. Hope you had a good breakfast. And sorry I have to present this from Newton, but let's give it a try. All right. So I'm going to talk to you today about data analytics tools and how I went from wondering how anyone actually used this and if it affected anything to really having a better understanding of how they work. So, hi, I'm Debbie Ginsberg. I am the faculty services librarian at Harvard Law School. Sorry, faculty services manager. There's several librarians, and I am an academic librarian. So my understanding of analytics is we've got a little bit of tunnel vision. By the way, can everyone hear me? Am I coming through okay?
I'm turning up the volume right now, actually.
Okay. So hopefully everyone can hear. So if you can hear me, what I saw about, everyone can hear? Okay. What I saw about what was going on with all these little analytics was a lot of hype and all this stuff it could do. So, you could do things like get all this evaluation of your judges and educate clients and really build this great strategy, or you would, really, have these great discussions with your clients and really give them a great understanding, and you could get all these advantages, and you were going to work smarter and you were going to save time with legal analytics. It was going to be great. And I'm like, does anyone actually use these? And when I'm looking at these numbers, I'm seeing things that look kind of meaningless to me because I don't understand what it means to say that, well, this judge grants motions to dismiss 25% of the time over their lifetime. What does this even mean? But it's a big industry. I mean, there's millions of dollars going into this. And so there must be something here I'm missing, something I don't get. So I went and talked to a bunch of other law librarians, a bunch of firm librarians to get their perspective of how they use analytics every day. And it looks like I'm wrong. And they actually have a purpose and they do affect certain kinds of behaviors. Let's talk about them. First, let's talk about what legal analytics are and get an idea of what we are looking at when we look at legal analytics. Because when I'm looking at them, I was focusing a lot on the judges, and there's a lot of information about the judges. So here's a typical example of information you can get about judges. And there's a lot of information about motion dismissed and whether they're granted or not, but I can also filter in many different ways, such as date, which is really important, motion type. I can get information about judges' experiences, about how long things take. I can get information about the judge themselves. I can see the different motions. So there's a lot of information I can get here about judges, and I can give them a chart and table, and I can manipulate this information as I need to. But it's not just judges that I can get information on. I can also get information about attorneys. So if I'm working with an attorney or their opposing counsel, I might want to know something a little bit more about them. So the typical example of attorney, and I can get an example of the kinds of work that they do, what case, how they practice in federal versus state, who they represent. I can get information through the references about what they've done. I can see their motions. I can see their outcomes. I can get information about their experience. So this could, this is kind of information I could use to, develop conversations with attorneys and clients. And it's not just attorney information I can get. I can also get the same information about firms. So if I'm looking to work with another firm, or if I'm in-house counsel that's hiring, I can get some idea of, does this firm have the experience I want? Have they worked in the court I want? Have they worked in front of the judges I want? What kind of motions do they file? What kind of language do they use? So I can get some good information about them there. So, all right, I'm starting to get an idea of the kinds of information that these analytics can provide. Another thing that they can provide is information about is experts. So, example of an expert that's available. This one is an expert in infectious diseases. So I can get the idea of their cases per year. And not surprisingly, it went up after 2000. Do they represent the plaintiff? Do they represent the defendant? Have they been challenged? What's the result of those challenges? What kinds of documents are available to them? So I can start to get a certain amount of information that's available to make good decisions about whether I want to use a particular expert or not. You can even see there's tags about the kinds of information, the kinds of cases that they handle and kinds of areas they're expertise in. In addition to judges, I can get information about courts from different kinds of legal analytics. So let's say I want to get information about the Northern District of Illinois, and I can say, okay, here's Rebecca Pallmeyer again, and I can get information about different judges, which judges rule faster, how do different judges handle motions to dismiss, who has experience, what kind of outcomes, can I see different motions. You can also see damages here, and I'll come back to that in a second. But also expert challenges are available here as well. So again, I'm starting to develop some ideas of the kinds of data that are available here. And speaking of, the other thing I can get is the kinds of cases they handle, and which kinds of courts have which kinds of cases. So in this case, I'm looking at eviction cases in state courts. I can see that for some reason Florida has way more than everyone else. So just a little hint here, if I'm looking for people who work with students, if you're looking for interesting research projects, some of this data might point to some good research projects for students as well. Why is there all this stuff in here? Why are all these evictions in Florida versus everywhere else? But I can get an idea of, all right, what jurisdiction might handle a particular area of law if I was doing research that I might want to look at. Back to damages, what kinds of verdicts are available? Traditionally, this has been really hard information to get, but legal analytics has made this information a little easier to come by. So I'm looking here at a verdict settlement organization. A lot of information I was seeing here is in Westlaw. This is in Lexis, looking at their verdict settlement analyzer and getting idea, okay, here we've got, a number of cases by resolution. There's 25,000 verdicts here. I can get different information about damages, what's worth more. I can narrow it down to courts. I can narrow it down through timelines, so I can get an idea of what my case might be worth in my court at a particular time. All right, that can be valuable as well. And if I am researching companies, I can get legal analytics about them too. So here I can say, okay, I want to know what kinds of cases a company is usually involved with. So I can see here, okay, this is Apple, and obviously they're involved in patent and IP cases and a bunch of others as well. So I can get all of this different information from these different analytics that are provided by different companies. And so it's much more broad than just the judicial analytics. That tends to be a lot of the focus, but there's more information available. The ones I've been showing you so far come from the big players. Lexis, which has context, which is available for law schools. Lex Machina, which is not. And Lexis also has the verdict settlement organization analyzer, which we saw. Westlaw has a lot of information about legal analytics. They seem to have a fairly wide range of materials, a bit deeper than some of the others. I'll show you what I mean by that for a minute. Bloomberg Law, obviously that's where I got the company information because they have the dockets, they have that available. Docket alarm is from Fastcase. We just got that at Harvard, and it's been an interesting place to look for analytics and docket information. And I'll show you some interesting things they're doing with AI in just a second. But I just showed you all of these analytics, but do they affect behavior? Do anyone actually change their strategies or anything based on the analytics that are available for them? And part of it is, what do I mean by behavior? So, when I was thinking, can we make, absolute certain decisions about whether to proceed through litigation based on motions to dismiss data? Maybe it's not quite like that, but there are places that legal analytics can affect and enhance litigator and researcher behavior. And part of it is legal research. So, for example, if I am doing a motions to dismiss or some other motion for summary judgment, or some other, preparing some other legal document for a particular judge, I can look in the legal analytics and get some idea of the kinds of cases a judge might cite, or the kind of language they use. So this is some language, posting some of the information I learned from the different librarians, and they said this is exactly how it's used. And it's not a replacement for a traditional legal research, it's an enhancement. So I wouldn't just look at the motions that a judge has done and be done with my legal research. I would still want to do the normal legal research I did, but I would have additional information about what works in front of that judge to help me prepare that motion or that document. Business development is another big area that legal analytics are used for. So let's say you want to pitch to a client that, yes, we are the best law firm to handle your particular case, and knowing something about their litigation history and what law firms they've used in the past and what they've done. So looking at the company information, looking at the law firm information, can get you some information, what you need to do to develop that your business case to say, yeah, this client, you should go with us. And apparently this is a really big use case for legal analytics. It does get used in litigation quite a bit, not just in terms of legal research. So let's say you're in front of one judge and suddenly you're reassigned to another judge. You may want to do some quick research into how that judge handles cases, how it's different, and be able to explain this to your client, what this change means. Research opposing counsel is a big one. So you might want to know, who are they representative, who they've represented, what kinds of suits they've been, what their win ratio is, who they've appeared before. You can look at their briefs, you can look at some of their documents and get an idea of how they respond. So this can help you, again, prepare your litigation strategy moving forward and help you with conversations with your clients. It can help you with timing. So big question clients have is, how long is this motion going to take? And the legal analytics can give you some idea. Oh, this judge takes 210 days to rule on a motion to dismiss on average. So this is sort of what we can expect going forward. So you can so when they talked about in the hype managing client expectations, yeah, these can really be helpful for that. And you can look at the overall analytics to look at to get overall strategies for your firm, because remembering the firm is a business and you want to be thinking about what is going to go in the future, and using analytics to look for changes and predict where things might be going can be really helpful. So these are some of the typical ways that analytics are used. These are some of the typical analytics are used. And so I'm thinking, am I wrong? But to a certain extent, I'm still wondering, was I wrong? I still have some questions about these analytics and how useful they are, even after all that. Because my problem is this. One of my problems is this. So let's say I have a question. What percent of motions dismissed has Rebecca Pallmeyer or Judge Pallmeyer granted in the last 5 years? So I go to Docket Alarm and I can see that they have this big gap in 2021. And despite that being COVID, I'm pretty sure that during that time, Judge Pallmeyer was granting orders to dismiss or orders denying dismissal during that time. And I checked some other analytics as well from other companies, and I can see, all right, Westlaw says about 800 motions during the 5-year period, and about 40% of them are granted. And then I checked, this is Docket Alarm again, and then I, got 99. Doesn't even seem to include that gap, but it's still 40%. But I know that 99 and 800 are not the same number. And in looking at other analytics, sometimes I had people, I think I had one that said it was like 55% of the time. So I was starting to get a little confused as to what these, the fact that I can't get this level of precision that I expect from my legal databases, I found a little frustrating. The other thing is, it really doesn't show the whole picture. These are numbers, but they're numbers sort of without context. And here, when I was asking the librarians about this, they definitely agree that there could be some issues here. So let's say I am looking at win rates for a particular attorney, but it shows like I won this case, but doesn't show that it was a good loss. And in many cases, of course, law firm is representing a client that knows they're going to lose, but the idea is to make the loss less bad. And it doesn't show that. And it doesn't necessarily get into the political nature of judicial appointments, which again can affect a lot of these numbers, particularly over time, not to mention the role of law clerks, which can also affect the efficiency of a judge at any given particular time. So there's aspects of this that are not going to be shown by the numbers. So here I'm looking for precision. Here I'm looking for the big picture, everything that's in the picture. And I'm like, coming here with my reference library and brain, but to a certain extent, doesn't matter. And I got to think about that, because the law librarians agreed, yeah, there's a lot of hype. If judge might grant 28% of motions to dismiss, but what does that mean across all cases? Is it uncontested or ones that were argued? What are we talking about? But even so, to a certain extent, it doesn't matter, because everybody understands the data isn't great. It might have 55% of all of the motions that this particular judge has done, but it's something. And this is not necessarily about the precision that we are looking for in legal research. Instead, what we're using the data is to create a story to tell the client, or to create information to make a decision for the company. And one librarian said, hey, the docket alarm reps said this is about defining the gray. And the great thing about defining the gray is, without any data, there's nothing to define it at all. And while it's evolving, it's giving us an area that we can operate that otherwise would be really difficult to navigate. So as another librarian pointed out, at the end of the day, something that has some data is more compelling than just a basic gut reaction. Even from a very experienced lawyer, data is better than just what's in my head. It gives me a little bit more to ground my information on, to ground my decisions on, to ground what I want to do going forward on. So when I'm thinking about data analytics, what I have to remember is, what's the actual purpose of these analytics? Am I looking for absolute precision, like I am for when I'm looking for something for legal research, where I want to make sure if I say the answer is this, the answer is actually that? And here the answer to that is no. This is about telling a story. It's about providing a framework. It's about having discussions with the client. It's about making them understand, translating what's going on in legal land to what's going on in their land, so they can get an idea of what to expect going forward and what to expect from the case. And that is why in this case, something is better than nothing, because it gives you information to ground the discussion on. And this is a case where good enough is enough, because this is not about coming up with absolute certainty. So this is not saying to a client, hey, based on this data, we absolutely should do this. It's providing enough information to the lawyer and the client to make good decisions going forward. So, because AI must be mentioned in all this, what about AI? How is that going to change things? We're not seeing a lot of change yet, and I expect that to change more drastically over the next few months. One of the things I did not get into very much here is a lot of these data analytics companies provide APIs, which are really important to how a lot of law firms work with this data, because they can pull the data and run their own analysis. So in the future, I expect that there'll be more AI involved in this part of this, because this involves the very large amounts of data, which is where AI does a really interesting job with. What we are seeing is, and I mentioned that Docket Alarm was doing some interesting stuff, is uses of extractive and generative AI to provide additional information. So for example, Docket Alarm is using extractive AI to say, this is an order, this is a plaintiff's motion, this is a defendant's motion, and you can get a timeline. If you're looking at the docket, you can quickly see where the motions you want to look at, or the documents you want to look at. And I found, as a researcher, this is really helpful, because otherwise looking at a docket can be a bit tedious, but being able to narrow on the documents I want can be really helpful. And this is why the Docket Alarm reps said there's probably that gap for Judge Pallmeyer, is maybe the extractive AI just hasn't identified those documents yet, but hopefully will in the future, and can fill in that gap and provide more precise information. Hopefully it will soon agree with Westlaw, or at least one of the other databases. They are also using generative AI. In this case, they're using ChatGPT to do summaries of documents. So I don't have to look at the entire document, when I am trying to decide if I want to, this is the document I want to pull and research further or not, I can get quick summaries from the documents that have already been pulled by generative AI and say, oh, okay, here's a quick summary of what's available. So that's an interesting use of not, looking at giant amounts of data and summarizing them, but helping us navigate the system bit by bit using ChatGPT and similar tools. And this gets us into, okay, what should students know about this? Because it's not the kind of thing we don't normally talk about, because we don't spend a lot of time talking about the business of law in many of our legal classes. We don't have a lot of time, so we don't get to a lot of this information. But it could be the kind of thing that, as an associate, a partner may say, hey, can you go get me some of this data so we can make a decision? So students should know that they exist, and that they are part of the legal research platforms they have available to them. They should know why they exist. They should know, if you want to do this kind of research, this is the tool you should go to. So we've heard a lot in this conference so far about students not knowing where to start. And sometimes they don't know where to start because they just don't know that tool is out there. So at least giving them some idea of, like, wait a minute, someone mentioned at some point that there's a tool that I can use to research opposing counsel. I wonder what that was. We can get an idea of, all right, this is what I should do next. But at the same time, we want to alert our students that they should be, oops, lost my thing there, current slide, that they should be very careful, because this is data that can go off the rails really quickly, because as we saw, it's not the same from database to database. And so we want them to think about some of the things that we've been telling them about when they're doing legal research, such as limiting the field, so that, if you're going to look at this data, if you saw when I was doing the information about Rebecca Pallmeyer, I could have looked at all of the years she's done, but I limited it to the last 5 years, or I could limit it to a particular kind of case, or I could, limit it to, particular kinds of motions. So, I want to think of, like, the same way you filter in legal research, you want to use those same filtering skills when looking at this data too. And we also want them to be aware of what data are they looking at? What is in this data versus in this database versus that database? And we want them to be thinking about that for legal research too, because when it comes to, like, you see, if you go to your legal research database and it says selected cases from 1980, we don't know what that means. And here, what does it mean that we don't have all of the cases from Rebecca Pallmeyer? What do you have? Is it going to be helpful or not? We want them to be thinking at a level like that when they are considering what data they want to use, whether it is for legal research or for analytics or for anything else they're doing. So, we've figured, so after all this, I'm figuring, okay, this is useful. And it's not just useful, it's something I want students to know. And I want them to know because I want them to know that in the sense that it's going to be useful for their future work. And it's going to be useful for them to think about what data is, not just research data, but all kinds of data, and how it is that they're going to have to think about it on a really high level whenever they use it. So at this point, at the end of the conversation, we're going to have questions, but I believe it is now Renee's turn to come talk to us about what she's working on. So I will end this and stop sharing my screen.
Thank you, Debbie.
Stop share wonderful there. I'll go to mute.
Okay, thank you all. My name is Renee Danser. I'm at the Access to Justice Lab at Harvard Law School, and I am going to follow Debbie's talk about legal analytics and talk about the ethics of not knowing. So the importance of using data to know if your solutions work. and the importance of kind of weaving that into access to justice education. So we're going to move from firm culture to the process of representing folks who often don't have active representation or who are of modest means. So I want to talk about the importance of coupling access to justice education and solutions generation with rigorous evaluation and data analysis. Okay. All right. So access to justice education typically focuses largely on solutions to close the justice gap. But what if those solutions aren't doing what we hoped they would do? There are these, what you see on the slide here are just some examples of solutions. I bet you can think of lots more as you sit here today of solutions to help the underserved populations of our country. But as a community of practitioners, we are solutions oriented, but often evaluation phobic. We tend to rely on what feels right, and this is what Debbie mentioned, right? Some data is better than no data. We rely on what feels good, like a good idea to improve the ability of justice system users to meaningfully engage with their cases, but we don't typically go to the next step of knowing if the good feeling is justified. We don't evaluate our solutions very well. So I'm going to use my time today to give you some examples of surprises, successes, and disappointments on the journey to know if access to justice solutions are doing what we hope they would do. And my hope is that you come away from this talk seeing the value of not only solutions generation, but evaluation completion afterwards. And I'm hoping you see that value so clearly that you then begin to kind of weave that message into your access to justice education components. So let's start with the surprises. Those are always the most fun. At the Access to Justice Lab, we do conduct rigorous research about access to justice solutions. And so all of the surprises, successes, and disappointments I'm going to show you are coming from our cadre of evaluations that we've at least attempted, right? So I've given you 2 examples of surprises. I'm going to give 1 example of the other categories simply because of time. So on the left side here, you're going to see an example of a program that was designed to incorporate mandatory domestic violence training, or counseling, excuse me, for defendants who were convicted of a domestic violence infraction. So in the evaluation, the way folks came into the study is they were convicted of a misdemeanor domestic violence charge, and they were either sentenced to 1 year of probation, or they were sentenced to 1 year of probation and 6 months of mandatory domestic violence counseling. And so at the Access to Justice Lab, we do empirical research, and our methodology is the randomized controlled trial. So folks were randomized into one of these groups. The status quo was the 1 year probation. So what we were doing was adding this domestic violence counseling or mandatory counseling onto that 1 year probation and hoping, right? We hoped that it would change rearrest rates and reabuse rates. We also hoped it would change the attitudes of defendants and their beliefs regarding domestic violence. So it turns out, though, that there was no difference between the 2 groups. Forcing counseling on folks did not change their rearrest rates, it did not change reabuse rates, and it did not change attitudes about and beliefs about domestic violence. And so this was a surprise. The jurisdiction that implemented this counseling really believed that this was the solution to victimization. It turned out not to be, though. So the other surprise on the right is online dispute resolution. So in this jurisdiction, they were using online dispute resolution, which is the opportunity to resolve your case online, right, at any time. And so the idea is that it's perceived to have more convenience, right? So you can resolve your case at any time because it's online, so you don't have the inconvenience of court hours, which tend to be business hours during the day. And you also can do it from anywhere where you can access the internet. So that can be on your mobile device anywhere. It could be at a library or other internet hub. It could be from your home, right? And so there's also perceived convenience there as well. So in this instance, in this jurisdiction, they were using online dispute resolution to resolve traffic cases. So someone was issued a traffic citation. The citation included information about online dispute resolution on the citation. We can talk about whether or not that's the right place to put it, but we can do that at another time. I have strong feelings about this. Individuals were then registered for the online dispute resolution platform. And in this evaluation, and they could complete their, if you register for the platform, that doesn't require you to complete your case on the platform. You can still do it the traditional way. In this evaluation, we would have rather randomly assigned you either use the ODR platform or you go to court. But we didn't do that. We didn't do that because there wasn't really an appetite for that at the courthouse. So what we did was randomize encouragement to use the platform with the expectation that folks who were encouraged were more likely to use the platform. And if they were more likely by large amounts, then we could effectively see the difference between using ODR as opposed to going to court. So as folks were registering for the ODR platform, they were either randomly assigned to proceed as normal. They could either continue on with the platform or go to court, or they would receive some encouragement to use the platform. So what we saw was not any difference in the usage of the platform. The usage rates were the same. But what we did see was a large reminder effect, a really large reminder effect. So litigants who got the encouragement resolved their cases at a much, much higher rate than those who didn't. They didn't resolve their cases on the ODR platform at any higher rate, but they resolved their cases generally. So whether they did it in court or did it on the ODR platform. And they did that at a 23% higher rate than those who didn't get the encouragement, which is very high for other kind of studies about reminders. So there's lots of studies out there, not just in the legal space, but in other disciplines as well, about the effect of reminders and if reminders get people to do stuff. So as Debbie mentioned, how do we affect behavior? And reminders have some proven effect. In this case, it was much, much higher. So so our surprise here was we weren't looking for a reminder effect generally. We were looking for a reminder effect on the ODR platform itself. And so our surprise was how do we explain that? And so we can't without additional research, but what we can make some suggestions. And so what we think might have occurred was reminding people, coupled with the perceived convenience of an ODR platform, kind of encourages and increases resolution rates, even if it's not through what you perceive to be the most convenient route. I will also say that this evaluation did occur during the pandemic. The court had completely changed the way they were adjudicating traffic cases, such that they were all online, whether it was in business hours or not. They were using Zoom, and so the location convenience might have been really muddied there. So moving on to, there we go, successes. We'll do what is often the most juicy, are the disappointments, last. So we'll move to successes. This example is an example that is currently, we're still in the data collection phase, but we are done with enrolling people into this study. So we have some interim successes in this evaluation. This is about the effect of full scope legal representation for expungement cases. And in this evaluation, we are again recognizing that we cannot randomly assign who gets an expungement and who doesn't. That is not our decision, right? That's the judge's decision. But what we did expect is that if somebody had full scope legal representation, meaning a lawyer from the start to finish of their case, that they would be more likely to achieve an expungement than even those, and in this instance, even those who are working with a guide and file or a guided interview style petition and a 30-minute consult with a lawyer about whether or not the pleading is sufficient, what they should expect next, how to file, right, those sorts of things. So we expected that full scope representation to be so much better that it would effectively randomize expungement. So those folks in that full scope representation group would be successful at expungement so much more than the folks in the other group, that we could then study the effect of expungement on housing and employment stability, which is actually the true point of the study. It wasn't necessarily to understand the effect of counsel on these cases. However, the effect of counsel on these cases is really integral to this study. And so you'll see folks who are eligible for expungement, they do need to contact legal services. Expungement is that kind of type of case that straddles that criminal civil line. So you're expunging a criminal record, but that is a civil matter, so you don't have a right to counsel, so you need to go to legal aid. So they go to legal services, and at legal services, once the legal services agency goes through their typical eligibility screening, they were either assigned randomly to receive that full scope representation or to that online guided interview plus a 30-minute consult. And again, we're hypothesizing with the full scope representation that they're more likely to succeed in expunging their record. And if that hypothesis proves true, they're more likely to have improved housing and employment stability. If they are in the online guided interview and the 30-minute consult, we think that they're less likely to succeed in getting their expungement. And then, as a result, less likely to have improved housing and employment stability. And so what we can tell from this study, I told you we're still in the data collection mode. We are collecting housing and employment data for 5 years for folks, because we really want to give an opportunity for folks to stabilize. So we're doing that part now, but the initial hypothesis proves true, right? So we can tell who is successful and who isn't at this point. And it is a huge gap. And so that is successful for the evaluation, unsuccessful for society. So just want to totally acknowledge that. And I think that there's important kind of policy implications about that, is should we have a strictly paper-based administrative process be so difficult that somebody needs an attorney? Again, we can talk more about that if you want to in a later time, because that's a whole session on its own. Okay, so let's move on to disappointments. And so this evaluation was about the provision of rideshare credits to folks to get them to court. And so we recognize transportation, or we often cite transportation as a challenge to getting to court for folks of modest means, or most people. I mean, not just folks of modest means, but that is an access to justice issue. And so we wanted to understand if providing rideshare credits would improve the ability of folks to get to court. And so in this instance, folks were coming from, these were folks in criminal justice matters. They would proceed to their arraignment, which is their kind of first discussion about whether or not there's probable cause to continue on with the case. They would, in this jurisdiction, after arraignment, they were required to transit themselves down a few floors in the courthouse to register with pretrial services, and pretrial services' responsibility then is to monitor the individuals to make sure they come to court or complete any of their pretrial requirements, right? Once they registered for pretrial services, we were then randomizing them to either receive 3 round-trip rideshare credits or to get no rideshare credits, which of course is the status quo, right? We tell people to come to court and we don't ask them how. So that was, so folks got 3 round-trip rideshare credits for any subsequent hearing after their arraignment. So this is a disappointment, not because we think this is a bad idea, right? We do think transportation is an issue. There are other studies about transportation providing transportation in different disciplines. For example, there is one study about providing taxi vouchers before rideshare, right? Providing taxi vouchers to mothers who need to get to prenatal appointments. And that study showed that no one used those vouchers, but they did go to their prenatal appointments more often when they had the vouchers than when they didn't. And there's also some studies about providing public transportation credits that show that folks use public transportation more frequently to get wherever they need to go, not necessarily to the place where you had hoped they would go with that credit. And so the issue may be more about just generally, folks need transportation to do the things that life requires. So in this study, we didn't see much difference, right? We didn't see anything different. The folks did not, nobody used the credits. We had like 6 people use the credits. None of them were round trips either, by the way. They used like 1/2 of a leg of a round trip. And so the question is why? And so I'd say this is a disappointment, but I don't think it shouldn't be tried again. I think there's some learning to do about how this study was implemented. So first of all, we were asking pretrial services officers to be the ones to bring people into the study as they're also signing them up for their services after arraignment. Arraignments are done in a cattle call. You have 90 people come in at 9 o'clock. That means pretrial services are receiving clients in a cattle call. So they're busy. It was just not the right time or the right entity to be enrolling folks in the evaluation. They also, because of the constraints on their resources, they had created a process that wasn't nimble. They were asking folks to call, so pretrial services also scheduled the rides for folks through the rideshare app, because we did not require people to have the rideshare application on their phone to use the credits. And the pretrial services department was asking folks to call them between 7:30 and 8:30 in the morning, and that was it. That was the only time they could get the rides. And like, no one is at their best at 7:30 in the morning, so it doesn't matter who you are, right? So this is just, that wasn't a good, nimble process. And so we did make changes, but it didn't change much about the success of the study. The other thing was, we suspected, and all of these whys, by the way, came through kind of a dialogue with the pretrial services agency. So it's not just kind of me saying, why did this happen? Let me tell you what I think. We suspected that there was a distrust, right, of the system actors who people were enrolling with. One of the enrollment questions was, do you have access to a vehicle? And of course, if someone says no to that, that may make it seem like they can't get to court. And of course, that's a problem when you're trying to stay out of pretrial incarceration, because one of the criteria is, are you coming back to court next, right? And then the length of time between the time when people were brought into the study and their next hearing could be 6 weeks, it could be 10 weeks. And simply people forget, right, that they have this opportunity. And so I would say, don't give up on rideshare credits, don't give up on figuring out the transportation solution, but this was a disappointment because we didn't figure it out here. Okay, so I think the takeaway from my talk, and then what I'd like you to remember, is we need more than gut feeling. We aren't always sure if the interventions that our partners want to implement or are implementing work, but they are. They're always very, very sure they work. And it comes from a really good place. So part of educating our students about access to justice is also educating them about the idea that not everything will work, and we should try to find out if it does, because we don't want to cause unintended consequences for the people we're trying to help. I mean, ultimately, this comes down to the people we're trying to help, right? So I want you to leave the session understanding or thinking about when it is unethical to not know. If we have all of the data that Debbie, for example, mentioned, or that that we have from the court, if we have the ability to access this data, when does it become unethical to not do it, to not know that something works? Okay, that's my talk for today. I'm looking forward to all your questions. You can reach me here or at that email address. Do you want to bring Debbie back on the screen?
Yeah, I think she just needs to enable her video too. Yeah,
Oh, okay. There she is.
Hi.
We want to see you, Debbie.
Hello.
Big instead of me, instead of mine. That's a great idea. Let's make Debbie the face.
Debbie, we're making you bigger.
I think we have to be true to the schedule, right? We have just a couple minutes for questions.
15.
15. Oh, okay, great.
Oh yeah, we got the 15 we planned.
Okay. Yeah, go ahead.
So I'm wondering, in your work in access to justice, are you a lawyer? Are there roles for non-lawyers in the access to justice world, and what are they, and what skills should I develop if that's what I want to do?
Yeah, so I am a lawyer, true confessions, but there are definitely spaces for non-lawyers in access to justice, and in fact there is an entire movement right now about providing representation or advocacy for clients from folks who are not law trained, because you have experiences and expertise that are different than lawyers. You also are in the communities that folks are coming from, and you have a different level of trust and ability to navigate those systems. So as far as training is concerned, I mean, there is kind of, I think, some formal trainings out there for folks who are trying to be kind of those non-lawyer advocates in justice systems. But I think really what you need to what would be best is just practicality. Like, how do you get from the start to the finish of really case types that are most in need? And in my opinion, and take that for what it's worth, because you could talk to lots of people who have different opinions, those are those high volume case types where you're seeing the most folks who cannot get representation for one reason or another, likely because of income. That's going to be family law cases, that's going to be eviction cases, that's going to be debt collection, or a civil, like, forfeiture type cases. So these are the case types that are the most, like, central to people's lives. And so that's where I would focus if I were you and wanting to get into kind of advocacy in the justice space for folks who can't afford lawyers. Debbie, I don't know if you had other thoughts on that.
On how to get into, no, I don't, because my experience in working in access to justice is like 30 years old. So
we can be surprised how little has changed, I'm sure.
Yeah.
Any other questions or thoughts? Yes.
When working with clients, and you often you said you go into it, they think they know what the outcome is going to be, and so they sort of structure it hoping for a particular thing. How much do you find you need to negotiate the question as opposed to wait for the answer to see what it ends up being? Because sometimes it might seem like you reject the premise of the question and it's like poorly implemented. And you kind of talked a little bit about that in the examples there.
So we don't really ever reject the question, because research is about investigating the questions. I have a problem with providing unsolicited advice to folks, so I will definitely talk through what I think will be challenges, and I have studies that I work on where I'm like, I do not think this is working. But those are the best, right? Those are the best studies when you kind of have a disagreement about whether or not this is a good idea to begin with. What we do try to nudge people on is thinking beyond just, does this help this individual case, right? Are we getting to a quicker resolution of this case? Are we getting people to win more often? What we try to think of, and the expungement study is a very good example of that, is we're not, in that study, we're glad to see, for the study purposes, about the difference in success rates between those with lawyers and those with full scope representation and those with limited scope representation. But what we really want to know is, what does expungement do for society, right? We want to know, does that improve housing and employment outcomes? We suspect that it does, and we're trying to see if that's true. And so what we really do, most of our negotiation, sometimes we center negotiation around process, because there is value in kind of the whole study design process forces someone to evaluate and interrogate the way they're processing the case generally, and there's lots of value in that. But what we really push on is trying to ask people to think about, what do you think this is doing beyond this case? What do you think are the long-term effects on individuals and communities because of what you're doing? Because that really is kind of what access to justice is about, is not just kind of individual isolated improvements, but long-term systemic societal improvements, right? Yes. Oh, I'm sorry. You, yes, and then yes.
So, in a number of your examples, you anecdotally identified factors that were actually improving services, right? The prenatal counseling, it wasn't about the buses, it was about the additional touches to, you imply that it's the additional touches to the pregnant women that get them to have more services. ODR, it's the additional encouragement. The rideshare failed because it came from the very cumbersome process rather than from a third party that was encouraging them to be in that. Are you able to start to quantify those network effects as a way to start talking to the direct providers and say, okay, we're seeing a meta pattern, let us study that pattern, let us think about how to intervene?
Yeah, that definitely is kind of like phase 2, maybe phase 3, right, of these projects, is to see failures actually tell you more than successes do. I mean, we definitely want to get to successes, but failures give you this runway to think about, like, why did that happen, and let's see if we can understand why that happened and how to change that. And I do agree. I mean, I can't know for sure, and we do need to test this, but I agree, I implied, and you can probably guess from that implication, that I do think that more proactive kind of outreach to folks is really what they need to help them get through these processes. Because nobody wants to go through the justice system process, and so if you can kind of hide away from it, you would love to do that, and sometimes you can, and they forget about you, but oftentimes they don't, right? So it's good to, I would love to kind of test that meta effect as you describe it, yeah. We do have an evaluation that's in the field now, and we are doing a couple more about kind of upstream proactive outreach. It's just really hard to show that something didn't happen as a result of this proactive outreach, but we're going to try, right? Just because it's hard doesn't mean we're not going to try. Yes.
Yes, so we have a couple of questions from the Q&A.
Oh, great.
Sure. So the first one is for Debbie. In your suggestions for how schools should teach students about legal analytics tools, do you get into how they should be critically analyzing the tools? For instance, how Westlaw uses docket data for the litigation analytics, while others may use only case law, which would explain the stark difference in sheer number of outcomes between platforms. Not all cases result in a published case, therefore dockets will be a richer data set from which to analyze outcomes.
Yeah, so Megan makes a good point there in terms of all right, what is this actually used? And that's sort of what I was trying to get at in having the students think about critically about what data is there, particularly when sometimes it's hard to get that information from the database itself, though some asking vendors doesn't always help me either. Well, so I said, I found this discrepancy, can you explain it? And sometimes the vendors will provide great explanations, which again is a good thing for students to know is, all right, I'm guessing, based on the numbers we're seeing here, this may be just looking at case law versus dockets. So I want to determine, but I can't know for sure because I can't get the vendors to tell me. So I want to base my information on that. And sometimes just knowing that I am working with an unknown set of data and I have to proceed accordingly versus other sets where I know exactly what's there. And that's part of the thinking critically of what am I working with? How complete is it? How do I determine what's there? And no one has time to go and count. So you're just gonna have to make your best guess. And again, because this is being used for more for storytelling, more for having conversations than for making absolute determinations, it's not as critical as when we see these discrepancies in our legal research, but also being aware that it does occur there. And so when you're doing our legal research, just like when we're looking at this data, we may not seeing the full picture. I hope that answers that question.
Yes. So our next one is for you, Renee. What is the end result of the studies? Are you going to be enacting policy change, especially with regard to the expungements?
Yeah, so we definitely take the role as the neutral researcher, but we hope to arm, all of our communities and advocates and our field partners with the evidence to then proceed with policy action. It is a hard role to play as the neutral researcher when your real, passion is access to justice advocacy. So in the expungement study I did talk about how there are some policy things to consider, and one of those is, do we want an administrative process that requires a lawyer? Is that what we intended maybe it was what we intended when we started the expungement statute, but is it really still what our value today as a society? And if it is, fine. Then we need to perhaps pursue a right to counsel movement for that particular set of cases. If it is not our intention, if that's not what we intended, then do we need to consider simplification or automation? I'm a big proponent of if we know someone deserves this or is eligible for this, why are we asking them to ask us or to tell us that they're eligible when we know that they're eligible? So considering some solutions like that. And this study is happening in Kansas, and there is some policy making going on as a result of some of these interim results. And we do work, so I mentioned this is about really housing and employment stability. We are working kind of in lockstep with the Kansas Department of Labor because they also would like to understand how to improve employment stability. And if this is a measure that is something that they would then take up. So we don't necessarily do the policy advocacy, but we work with those partners who would like to use the evidence to do that. And that is definitely a goal of creating evidence, not just to create it and let it sit, but to let it be used. Yes?
So after you do these studies for your clients, is the data then perhaps scrubbed and released for public consumption?
Yes. So we de-identify all the data and we post it at a whatever data repository. So we receive grant funding, or we look for grant funding for all of our evaluations. So when you say clients, I kind of cringe a little bit because we're not actually asking folks to pay us to do the work. So oftentimes, I only say that because the funding can often dictate what data repository we put them in. So if it's federal grants, they have their own kind of place, but otherwise, we will post it. We will post on our website where we've put it as well. And then we are kind of making a big push. We have like a really big set of data from looking at risk assessment tools. And so we are going to not only publish it, but publish that we're publishing it so that other folks know it's there, right, to use. Data is hard to come by in the state courts. So Debbie is showing you data about the federal courts. It's hard to come by in the state courts in any sort of easy way, like what Debbie showed.
There is some data in the state courts, but it tends to be much sparser. And the big problem with the state and the state courts, both for what I was talking about, what you're talking about, is there's no normalization. So what might have one, even county by county, so even in the same state, it might be hard to normalize the data to come up with good information.
Yeah. Yes, I got it.
Renee. All right, I'm gonna throw a hardball at you.
Oh, okay.
In what ways does strengthening or researchers, as neutral researchers, strengthening the procedural accessibility to the courts does more to undermine access to justice without disrupting both the root causes of why someone's in that situation? So in a criminal case, you have to say cannabis possession, which is now legal, but that person still needs a expungement. In addition to the Byzantine or disparate power imbalances when they do get to court.
So how does research improve upon the
Well, I would say strengthening the accessibility to the merit procedures does more to undermine access to justice in a whole, then by reinforcing the status quo, then addressing some of these more root causes and or power dynamics.
Oh, I see. So your question is, if we're making it easier to access the court, is that actually undermining access to justice because we're not addressing kind of the systemic reasons why folks can be justice involved?
Yeah.
Yeah. Yeah, agreed. So I mentioned earlier, I think, we have, in some of our evaluations, moved to thinking more about upstream solutions and evaluating upstream solutions as a justice system avoidance mechanism, not necessarily trying to improve upon making the processes that exist now in the system more accessible, maybe abandoning trying to even improve those processes, right? But trying to give people tools and communities tools to kind of just avoid the system altogether by addressing kind of those systemic challenges. So one example I can give you is we're working with two legal services providers that provide holistic legal services embedded in institutions that have mandated reporters to a child protective services agency, so a medical and an educational setting. And the goal is to divert folks from being reported by those reporters who are, being reported for issues that are related to poverty or systemic barriers to successes in their communities, to divert them to those medical, legal, and educational legal partnerships as opposed to getting that report. We know that reports to the Child Protective Services Agency far and away become unfounded, or meaning there's an investigation but they don't file a petition, but that doesn't mean there's not harm. An investigation causes harm. We also know that once a family is reported, they're more likely to be reported again than if they hadn't been reported at all. So we're hoping to kind of avoid those reports. But this is the challenge that I mentioned, right? How can we tell that it's a difficult challenge to tell when something hasn't happened, right? Like we are avoiding this report, but we're gonna try. So I totally agree with you that just making the processes easier may not be addressing the real issues at hand. Thank you. I think we are at time, but I'm happy to take questions off. Thank you, Debbie.
I can hang out.